Thank you everyone for being with us again this week. I wanted to start this week by first telling you about an excellent new program that we have in the works for the fall. Bond's Labor Department is very happy to be telling you today about a breakfast briefing where the topic will be managing the struggling employee, mental and emotional health in the law. This is a topic that we get questions about a lot, and we appreciate all of you who provide us topic ideas through this webinar, and mental health issues is something that comes up a lot in your requests. So we're going to devote an entire program to it in the fall. And it's not on our website yet, but it will be. It will be an in-person event. And we'll cover many aspects of how to deal with an employee who's struggling with mental health. So just wanted to give you that breaking news today. So with that, I want to introduce our set of presenters today. We'll start off with myself. I'm going to give a bit of a COVID update. We haven't done that in a very long time, but I'm going to hit that today. And then we'll move on to Amber Lawyer, who is here in Syracuse in our business department, talking about credit card surcharge rules, something that at least as consumers, we all experience and might find interesting, but business owners as well need to understand what the rules of the road are here in New York. After Amber speaks, we'll turn it over to Janelle Doobie, who's an associate here in Syracuse in our labor department, to talk about a new case out of the NLRB involving employee work rules that will impact your employee handbooks, and something you do need to be aware of. And then we're going to turn it over to Teresa Rusnak, who's out in our Rochester office in our labor department, to tell us about some recent guidance from the EEOC about hearing and visually disabled employees in the workplace. So with that, I guess I'll turn it over to myself. Don't have any slides today, but I'm just going to talk very briefly about for a COVID update. And I have to say that every time I speak, whether it's in person at a conference, or we're collecting feedback on this webinar, we seem to always get questions about the current status of COVID sick leave in New York State. I think there's still a bit of disbelief that it could still possibly be the law, but yes, it is. It is still the law in New York State, many years later, that employers have to provide paid sick leave for COVID. And I think this is sort of a timely presentation today. I don't know about you, but I've been hearing the word COVID a lot more in the news over the past few weeks. It's hard to believe, but we're in the 4th summer of COVID. And I just saw in the New York Post article saying how, the CDC data shows that each year we have a spike in the winter, but we often have a spike in late summer. And that's what the data is showing right now. It's too early to see what it really is, but we're seeing numbers go up. I don't have the numbers here on the screen today, but they are ticking up across the state. And, if you read the news, you're also seeing new information about a new variant called ERIS, E-R-I-S. I think that's how it's said. And, that might be accounting for why we're seeing numbers go up. And I know anecdotally in my life, I'm hearing news of acquaintances with COVID, which I haven't heard in quite some time. So with that really long wind up, I wanted to just refresh everyone's memory about the COVID leave law and also give you a bit of an update. So just a refresher, probably all know this, but based on the size of your workplace, you're required to give paid leave for employees who have a mandatory or precautionary order of quarantine issued by the state of New York, et cetera. Now, a couple things to point out. It says precautionary order of quarantine. We're not seeing those anymore. The CDC rules have changed so that we're not requiring quarantine for an exposure. So we're really not seeing, so that really would not be an issue. But there is still in New York the affirmation of isolation that employees can fill out if they are positive with COVID. And that is supposed to be still treated as if it were a government order. So if you have an employee who has COVID and they prevent an affirmation of isolation, you still need to provide paid COVID leave under the state law. Couple more things though. Just remember, it's calendar days. So if an employee comes forward on a Thursday, that means they get 5 calendar days. So Thursday, Friday, if they don't work Saturday and Sunday, you don't have to provide leave because they're not working, but that counts. And then 5 days would be Monday. Now the law still says 14 days, but the orders that are being issued are for 5 days. So really we're talking about 5 days of leave in today's COVID era. The other thing is that under DOL guidance, the second and third use of the leave has to be supported by a doctor's note. A home test would not be enough. So that is something that you can continue to enforce to try to control the use of this leave. However, this is really the most interesting part of my presentation here. There is a law that's been introduced in the New York State Senate to change the law and to sunset it, amazingly. And this is Senate Bill 7250. It's currently in committee. It was referred to the Labor Committee. It was introduced by Jeremy Cooney, who is a Democratic senator from the Rochester area. Some of you from our Rochester area might be familiar with him, but he introduced this bill. And basically what the law would do would be to change the maximum days of 14 days down to 5. It's not a huge consequence because most isolation orders are only 5 days right now, as I just said. But the most significant thing of Senate Bill 7250 is that it states that on or before April 1st, 2024, the Commissioner of Labor has to submit a report to the governor and a number of other officials accounting for the number of employees who have used this leave. And then if within 6 days of that report, it's probably 60 days, sorry about that, 60 days, the legislature does not adopt a resolution declaring the continued need for COVID sick leave, it sunsets. So it would require an affirmative act of the state legislature to keep the sick leave going next spring. Now, keep in mind, this is just a bill. We all know that a bill is not a law yet from our school days. And so we're just going to be watching this very, very closely to see if it moves out of committee and goes anywhere. But I know that everyone out there is looking for some glimmer of news that this law from 2020 might go away, and there you have it. We did post an article about this bill a few weeks ago, maybe a month ago on our blog. You can find that there, but it occurred to me that we hadn't presented on it in the webinar to my knowledge, so I wanted to make sure that we covered it. So that is where we are. Law still in effect, still have to pay attention to it, but change might be coming next year. With that, I'm going to turn it over to our next presenter, and that would be Amber talking about credit card surcharge rules. So Amber, go right ahead. Thanks for being here today.
Thanks, Kristen. Thank you for having me. Good afternoon, everyone. As Kristen said, my name is Amber Lawyer. I sit in the Syracuse office. I'm in the business department, and I'm a business associate and a cybersecurity and data privacy attorney. I'm here today to talk a little bit about New York State's credit card surcharging requirements and rules, and some general rules around credit card surcharging. We've had a bit of an uptick in questions coming in from clients in relation to credit card surcharging, what is compliant with New York State and throughout the country. And so I'm going to walk through some of that today. First, I'm sure you've all seen when you enter into a restaurant or any other business, credit card surcharging notices. So you walk in, you go to pay, you see a notice at the cash register that says you will be assessed a 3% fee if you're using a credit card. Originally, this was prohibited in New York State. New York State has a law called New York General Business Law, Section 518, which prohibited credit card surcharging. And the statute says no seller in any sales transaction may impose a surcharge on a holder who elects to use a credit card in lieu of a payment by cash, check, or similar means. A violation of the statute was considered a criminal misdemeanor. What happened with this law is actually in a case called Expressions Hair Design v. Schneiderman, a hair salon which had posted the exact notice I just described, a 3% surcharge, was sued. And that lawsuit went all the way up to the Supreme Court of the United States. And what happened was that the Supreme Court said the New York State law was regulating speech, in that it was telling merchants how they could impose a fee and regulating speech in that way. And the case actually went all the way up to the Supreme Court and back down to New York State. And New York State said, no, what we're not doing is prohibiting surcharging. In fact, what we're doing is regulating disclosure. So telling entities how they have to disclose surcharging. What does that mean? Essentially, what New York State says in the statute now, and the way it's being interpreted by the New York State AG, is that entities that want to surcharge may surcharge, but there are rules and requirements regarding the notice that you have to give. You have to provide consumers with notice of the surcharge, and you have to do one of two things. You either have to provide the dollars and cents amount of the credit card price up front. So if I'm walking in to buy a bag of bread from a grocery store and the grocery store is going to assess a surcharge on me for using a credit card, that price that I have to see has to be the dollars and cents amount I'm paying with a credit card, or it has to be a dual pricing scheme in which I can see both the cash or the credit card amount in dollars and cents. So you see this all the time when you're driving by gas stations. You see both the price of gas paid with a credit card, price of gas paid with cash. If you are offering a cash discount, that's a different set of rules. But what happens in New York now is you have mandated disclosure rules. It's important to note that if your business is an entity that is processing sales throughout the country, there are differing state laws, rules, and requirements in relation to credit card surcharging. So 2 states currently prohibit surcharging, Connecticut and Massachusetts. Several other states have similar rules to New York in that you have required notice obligations and you have to provide the credit card surcharge assessment in a certain way. So what does that really mean for you and your business? You must post signs, notices, receipts indicating that you are surcharging for credit cards. So if you're offering a credit card surcharge, you have to tell the consumer before they pay. That has to be an open and obvious disclosure. That's why you see it on restaurant menus or at the door when you walk into a building. You have to post an obvious notice that you are going to surcharge in relation to payment. In New York State, you have to have that dual pricing mechanism that I talked about earlier. So you have to show the dollars and cents amount of the additional surcharge. What New York State was really saying is we don't think consumers are smart enough to calculate the price difference when paying with a credit card. And so you have to tell the consumer exactly what percentage you're assessing and then the dollars and cents amount that you're adding onto the price if they pay with a credit card. If you're offering a cash discount, some of these rules do not apply. So if your price is $10, but you're going to offer a $1 cash discount, if the consumer is paying with cash, that's different than a surcharge, and the state treats that different than a surcharge, and you do not need to show the dollars and cents amount. So there's some nuanced rules around cash discount versus surcharge, and how you would assess those towards your consumers. It's important to note that the consumer actually has to have a true choice. So if you're considering implementing surcharges on your consumers and passing on those percentage fees that you get from credit card brands, you have to actually afford the consumer a true choice. So they have to be able to pay in another form of payment. If you are selling goods online and you're in the e-commerce space and you really only allow consumers to pay with a credit card, then you cannot assess a surcharge because, of course, they do not have a true choice. If you're going to assess surcharge fees in other states, you really need to review the state laws in relation to notice, disclosure, if there is any requirement on what language needs to be on the receipt of the bill, and do an adequate review on how states interplay. The reason why is that if you are an entity that works in both New York State and Connecticut and California and Colorado, each one of those states treats surcharging differently. And so you want to ensure that you've done your due diligence in relation to surcharging in each one of those states and that you're compliant, because you can be assessed a fine from the New York State Attorney General's office. And obviously, as I said, the New York State law also involves a criminal misdemeanor. The next very important step in adding surcharging into your payment process is that you have to alert your payment card network or your credit card brands. So each individual credit card brand has its own rules in relation to surcharging. You have to review what credit cards you're taking in. So if it's Visa, MasterCard, Discover, any of those credit cards, you need to review the credit card brand rules before assessing any surcharge. First, you have to provide notice. So to each one of those major credit card brands, you would need to provide notice. Oftentimes, it's at least 30 days prior to commencing any kind of surcharging. So you need to put the credit card brand on notice that you're going to take the surcharge assessment that they're sending to you, the convenience fee that they're causing merchants to pay, you're going to pass that on to consumers. You need to alert them. You have to limit surcharging to your credit cards only. Your payment card brand rules limit surcharging on debit cards or prepaid cards. So make sure that you're assessing this surcharge only onto credit cards. You need to limit the surcharge amount to the cost of acceptance of the network. And what does that mean? That means if Visa is surcharging you 2.7%, of course, you cannot pass that surcharge on to the consumer of 4.2%. Really important note here is that you cannot discriminate between cards. And so that causes quite a bit of, causes several issues for our clients, right? Because some cards assess a 4% fee onto the merchants and some cards assess a 2.7% fee. What you cannot do is discriminate. So you cannot have a differential surcharging approach that's passed on to your consumers. What we often work through with clients is we review what they're currently being assessed by the credit card brands, and we pick the lowest percentage, and that is the percentage that they use across the board for all major credit cards. If you have any kind of discriminatory practice where you're setting a preferential approach for Visa, then you will be violating the credit card brand rules, and they could refuse to allow you to use their credit cards. And so it's really important that you make that assessment and you do not discriminate between any card. It's easier to just choose the lower percentage. And finally, the credit card brand rules also have disclosure requirements. And so those requirements include disclosing the surcharge to customers, both in-store and online. If you have a website, posting appropriate notices that alert consumers and customers at point of entry and at point of sale. This is really important to know. If you are an entity that only provides invoices, you need to ensure that you found a way to alert customers before the invoice that you're surcharging so that they have a true choice. Kristen, with that, I'll turn it back over to you.
Okay, thank you very much, Amber. I wanted to actually answer a question that we got in the Q&A about my presentation, because I realized when I saw the question that I meant to talk about this and I forgot. So since I didn't use my full 10 minutes, I'm going to just plop this in right now. The question is, what about covering time off for vaccinations? Great question, because there's going to be vaccines rolling out in the fall with a new formulation that I'm sure people will be encouraged to get. And the answer is that the law that provides time off for vaccines is still in effect. So you would still need to provide that 4 hours of time for the vaccination for the employee. That law expires 12/31/23, so this will be our last year of that unless something changes. The law that would give employees time off to take care of like their children getting vaccinations, that is gone. But for the employee themselves for vaccinations, you do still have to provide that time. So thank you for asking that question. I meant to cover it. I was just so excited about hearing Amber that I skipped over it. So anyway, I am going to now go back to the agenda. And we next have Janelle Doobie talking about this new NLRB case. Go right ahead.
Thanks, Kristen. Hi, everyone. So as mentioned, today I'll be talking a little bit about the latest decision from the National Labor Relations Board. The board's decision is going to affect nearly every employer that maintains workplace rules and policies, which is every employer. So on August 2nd, the board issued its decision in a case referred to as Stairs Cycle. Through its decision, the board adopted a brand new legal standard to determine whether an employer's workplace rules and policies infringe upon employees' NLRA Section 7 rights. The board's decision is particularly significant because it overruled the prior existing standard for evaluating an employer's facially neutral work rules and now establishes a stricter test that is more likely to render some employers' existing work rules facially unlawful. This is yet another example of the board constantly changing its legal standards. So in order to better explain and understand how and why the board got to its new standard, it's important to briefly revisit the history surrounding the board standard for evaluating the lawfulness of employer work rules and policies. The lawfulness of facially neutral work rules and handbook provisions under the National Labor Relations Act has been heavily litigated by the board in both recent years and throughout history, and impacts both unionized and non-unionized workplaces. So under Section 8A1 of the National Labor Relations Act, it's an unfair labor practice for employers to interfere with, restrain, or coerce employees in the exercise of their rights to engage in certain protected concerted activities, including the right to organize and bargain collectively. So in 2004, the board issued a decision called Lutheran Heritage, where it first set forth a three-pronged test to evaluate the lawfulness of employer workplace rules, policies, and handbook provisions. Under this Lutheran Heritage standard, if the rule did not explicitly restrict protected activity under the NLRA, meaning it was a facially neutral rule or policy, then the violation of the NLRA was dependent on a showing of one of the following three things. One, employees would reasonably construe the language of the rule or policy to prohibit Section 7 activity. Two, the rule was promulgated in response to union activity by employees. Or three, the rule was applied to actually restrict the exercise of Section 7 rights by employees. So although the standard calls for an evaluation under prong one of whether employees would reasonably construe the language of the rule to restrict protected activity, cases applying this standard after the establishment of the test departed from the board's originally intended standard by inquiring only whether the rule could be reasonably construed to restrict Section 7 activity, not would reasonably construed to restrict Section 7 activity. This expansion from would to could resulted in a greater likelihood that employers' ambiguous work rules would be deemed to be unlawful. So that was the standard in 2004. And then nearly over a decade later, in a case called the Boeing Company in 2017, the board overruled the three-prong test set in Lutheran Heritage. And in its place, through Boeing, the board established a more employer-friendly balancing test. So Lutheran Heritage three-prong test was more employee friendly, and then now we have a test coming from the board in 2017 that's employer-friendly. Under the Boeing standard, when evaluating a facially neutral policy, rule, or handbook provision that, when reasonably interpreted, would potentially interfere with employees' exercise of their Section 7 rights, the board balanced the nature and extent of the potential impact on NLRB rights against the legitimate business interests and justifications associated with implementing the rule in the first place. Under the Boeing standard, the rule was considered to violate the NLRA if the employer's business justifications for the rule outweighed the adverse impact on employees' ability to assert their NLRA rights. So shortly after the board established its test in Boeing, the board felt the need to confirm use of the Boeing standard as well as clarify how to actually apply the standard. They did this in a case called LA Specialty Produce. And in that case, the board made clear that when evaluating employer work rules, it's the burden of the NLRB General Counsel to first prove that the facially neutral rule would in context be interpreted by a reasonable employee to potentially interfere with the exercise of their Section 7 rights. This was an important clarification to prevent consideration of whether an employee could reasonably interpret a rule to restrict Section 7 rights. So again, the board felt the need to make sure that there was no expansion of the standard from would to could. The board also emphasized in LA Specialty Produce that the Boeing standard is met only when a reasonable employee would read a rule to restrict protected activities. Based on this clarification, if a rule reasonably construed would not restrict employees' protected activities, then the analysis ends there and the rule is considered to be valid and lawful. However, if it is determined that a facially neutral rule would potentially interfere with the exercise of Section 7 rights, then the board would apply its Boeing balancing test, weighing the impact on employees' Section 7 rights against the business interests and justifications by the employer for implementing the rule. So in light of Lutheran heritage and three-pronged test being overruled by Boeing and then clarified in LA Specialty Produce, that brings us to present day and the board's current decision in Stericycle. So in framing its new test, the board considered the need and existence and importance of employers having these work rules, the importance in making sure work rules don't infringe on employees' protected activity, and they also considered the board's constantly changing standard when it comes to evaluating the lawfulness of these work rules. Ultimately, the board overruled the existing standard from Boeing and found that the standard that's applied there allowed employers to adopt overbroad work rules that had a chilling effect on the exercise of Section 7 rights. The board's reasoning for this is that the test in Boeing and LA Specialty Produce failed to account for an employee's economic dependence on their employers. So the board ultimately found that Boeing placed way too much emphasis on employers' interests and didn't require employers to narrowly tailor their rules to only promote substantial and legitimate business interests while avoiding burden to employees. So basically the board didn't like the balancing test anymore. So as a result, the board decided in its present day decision to revive and modify the original test it laid out in 2004 in Lutheran Heritage. Under this new framework, the board has implemented a two-step process. Under step one of the process, the NLRB's general counsel must prove that the challenged rule has a tendency to chill employees' exercise of their protected rights under the NLRA. If the general counsel is able to prove this, then that rule or policy is presumed to be illegal. Then we move to step two of the process. Once the general counsel meets its burden, the employer has an opportunity to rebut the presumption established under that first prong by proving that the rule advances a legitimate and substantial business interest, and that the employer would not be able to advance the interest with a more narrowly tailored rule. If the employer proves its defense, the rule is found to be lawful. So in working through this process, the board decided that it should be conducted from the standpoint of an employee who is economically dependent on their employer, rather than from the standpoint of a reasonable employee as under the prior existing standard from Boeing. The Stericycle decision is just the latest employee-friendly ruling from the board. We've seen a lot of our legal standards shift under this current board to a more employee-friendly standard. And all employers' work rules and policies, except those that on their face are going to restrict protected activity, will be subject to the board's new standard to determine whether or not workplace rules, policies, and provisions are lawful. So what does all this mean moving forward for employers? The board's decision is likely going to result in more work rules being challenged and possibly found to be unlawful. Employers should consider undertaking a review of their current workplace rules, policies, and handbook provisions just to ensure that they're more narrowly tailored to achieve the business interests and justifications for implementing the rule in the first place. And if you need help with that, we can help you here at Bond. So that's all from me.
Okay, thank you so much, Janelle. It's really kind of, you do have to chuckle a little bit, like it's back and forth, just typical NLRB, right? The standard just swings back and forth. It's sometimes a little bit difficult to keep up. But I know particularly with the employee work rule, issue. It's something that applies to, it's just a good reminder that it applies to all employers, even if you're not currently unionized. So sometimes it's easy to ignore, or overlook the NLRB's positions on some issues if you have a union-free workplace. But this one, again, does, I mean, everything does, but particularly this one, it's important to take a look at your handbook policies. So thank you for reporting on that, and also for writing that article that's available on our blog on this issue. Okay, so now we're going to talk about our other favorites, federal agency, the EEOC. Teresa's here from Rochester to talk about employees with hearing and visual disabilities in the workplace. Thanks for being with us again, Teresa.
Absolutely. Hello, everyone. Kathy, if you could go to the first slide, I'd appreciate it. So the EEOC has released some guidance, and just as a refresher, the EEOC is the Equal Employment Opportunity Commission. They are the federal agency that enforces workplace discrimination laws at the federal level. We have some counterparts in the different states as well. We certainly have that in New York, but today I'm going to be focusing on the federal agency because they're the ones that have released recent guidance. So in January, the EEOC released Hearing Disabilities in the Workplace and the Americans with Disabilities Act, followed by Visual Disabilities in the Workplace and Americans with Disabilities Act on July 26th. So I thought these two kind of worked well together. If you look at the guidance, which I've put the link to on the slide, they do mirror one another. The EEOC has extensive guidance on both with many, many practical examples in Q&A format, which I think is really helpful. But you'll see when you look at both guidance documents that they mirror one another. Both of these revise prior guidance on each of these topics that was first published in 2014. So this isn't the first time the EEOC has called out specific disabilities, but it is the first time in about 10 years that they've modified this guidance. So I think there's some interesting takeaways and certainly evidence of the EEOC's priorities and where they're looking to go in terms of enforcement. So next slide, please. Just as a reminder, the Americans with Disabilities Act protects applicants and employees with disabilities in the workplace. I find sometimes when I'm working with employers, and even for myself, we tend to leave the applicant part of that definition out. And that is something that you'll see the EEOC really enforce in this version of the guidance, is how accommodations need to be granted to applicants. So I think that's something really important for those employers that haven't looked at their interview process and how their interview process may need tweaks and changes to be accommodating to individuals with certain disabilities. I think this is a good reminder to do that. The Americans with Disabilities Act is enforced by the EEOC, so this is an agency releasing guidance on an act that it enforces, and individuals who believe their employers have violated the EEOC and the Americans with Disabilities Act can bring actions by filing an administrative charge, and that is a necessary precursor to going to federal court. As I mentioned, many states have corresponding state entities and statutory protections, including New York, but I'll stick with federal for now. When we talk about the ADA, or the Americans with Disabilities Act, it's really a twofold thing. There's some other nuances within these provisions, but basically it says you can't discriminate or harass your employees and applicants with disabilities, and you must provide reasonable accommodations for individuals with disabilities, absent undue hardship or direct safety threat, both of which we're going to talk about. So next slide, please. Beginning with applicants, and this is really one of the clearest things that I took away in reading this guidance, is the emphasis and the amount of time that the EEOC dedicates to talking about applicants with visual and hearing impairments or visual and hearing disabilities. The guidance is very clear that applicants need to be accommodated during the application process, and this is true even if the employer believes that the individual would not be able to perform the job. So they give an example, and I think it's a good one. And it also dovetails nicely into a case that the EEOC filed in federal court yesterday. So let me go through the example first. And this is the EEOC's example. An employer is impressed with an applicant's resume and contacts the individual to come in for an interview. The applicant, who is deaf, requests a sign language interpreter for the interview. The employer cancels the interview and refuses to consider this applicant further because it believes it would have to hire a full-time interpreter, presumably if the person got the job. The EEOC finds that that is a violation of the ADA. The employer should have proceeded with the interview using a sign language interpreter, And at the interview inquired what extent the individual would need a sign language interpreter to perform any essential functions requiring communication with other people, presumably once they're on the job. So what you can't do is, as an employer, have a deaf applicant or someone with vision loss or really any disability and say, we're not even going to give you an interview because we know for sure with this impairment you couldn't do the job. The EEOC is saying no, you have to grant accommodations through the interview process regardless of whether or not you think the person's limitations might impair their ability to do the job. And you need to make sure that you're doing it correctly. One of the things I think that we see with the EEOC is that they are going to start enforcing things about this guidance. So whenever the EEOC releases guidance on specific topics, they look to enforce it. You can kind of see that those are priorities for the agency. So to that point, yesterday I received notification from the EEOC, and you can sign up for their public notifications. I received a notification that they are suing in federal court an employer in Massachusetts for failing to grant a sign language interpretation accommodation during the interview process on these exact facts, that the employer thought that the person who had hearing loss wouldn't be able to do the job, so they didn't even give them an interview with a sign language interpreter. And that is a case the EEOC itself has now taken to federal court. So that's certainly not a position I think any of you want to be in. And I think it shows that this is a priority for the agency, particularly possibly in the applicant space. Next slide, please. Okay, another important thing about applicants is what we can and can't ask during the interview process, and that changes whether or not an offer has been extended or not. So in the guidance, the EEOC focuses heavily on employers not being able to ask about vision or hearing loss during the pre-offer stage. So you can't ask if people have medical procedures, whether they have a condition that affects their hearing or vision or that may cause a hearing or vision impairment. But you can, and I always encourage employers to do this, ask questions pertaining to the applicant's ability to perform job functions. So you can always give somebody a job description and say, can you do these things? Can you do the things on this piece of paper? Can you read labels? Can you work the night shift? Can you hear a safety horn? Those types of things, if they are essential functions of the job, you can ask about in the interview. But as far as targeted questions about disabilities or medical conditions, avoid those in order to not be in violation of the act. Next slide, please. So we talk a lot about what a reasonable accommodation is, and in the application process, probably the classic example in this area is giving someone access to a sign language interpreter or closed captioning or whatever they might need for the interview process. But there are also other accommodations, and these can occur during the application process or also once somebody is an employee of the employer. There's many more than are listed here. These are just the EEOC's examples. And if you check out the guidance, they have a little hypothetical for each of these 7 listed examples of reasonable accommodations. So I thought that was quite helpful. But accommodations can be things like time off, assistive or adaptive technology, reassignment to a vacant position, modifications to policies like changing your testing procedure or your training, changing your dress code, allowing guide dogs in the office when you don't normally allow animals, modifying work schedules or allowing telework, workspace adjustments, so adjusting the physical workspace, and altering non-essential job functions. Remember, when we're talking about the ADA, you don't ever have to provide accommodations that eliminate the essential functions of a job. Now, we could have a whole conversation about what function is essential and what function is non-essential. That's not the topic of this presentation. Frankly, we don't have enough time for it, but I will say this is just a service announcement to the employers to look over your job descriptions. This is something that you want to have clear in your job descriptions, and you as the employer want to be able to define what is essential and non-essential for each position that you have at your entity. Next slide, please. Okay, so I mentioned at the beginning that you don't have to provide an accommodation for a disability, including vision or hearing loss, if it causes an undue hardship to the employer. Now, an undue hardship is one of those legal concepts that has never been clearly defined, at least not to my satisfaction, but I can tell you this. Undue hardship is a high burden for the employer to prove. It means that providing the reasonable accommodation will result in significant difficulty or expense. That's going to vary depending on the size of the employer. What's going to cause significant difficulty and expense for a 25-person company is probably not going to be the same thing that causes significant difficulty and expense for a 2,500-person company. Employers don't have to grant the requested accommodation if they have an equally effective alternative. But the main thing here to take away is that undue hardship is a high burden for the employer to prove. It's a high standard for the employer to show. Not impossible, but certainly difficult. Next slide, please. And then finally, the other reason that you don't have to grant a reasonable accommodation is if doing so would pose a safety threat to the employee or others. One of the interesting things I thought came out of this guidance, particularly about hearing and vision loss, is how much the EEOC doubled down on what a high test it is to show that there is a safety threat. It can't just be a possible safety threat or a potential safety threat. It has to be a likely safety threat to the employee or others, and you have to have some evidence to demonstrate that. So I thought the example the EEOC gave here was actually very telling, because I think in this circumstance, a number of employers before this guidance would have said, this is a safety threat, but now after reading this guidance may need to think again. So for the example, the EEOC says an employee with a hearing disability requests training to operate a forklift at a large hardware store. For safety reasons, the employer requires that the forklift operators be able to communicate with a spotter employee while operating the machine. They explore whether the employee could be accommodated using visual alert on a smartwatch, a vibrating pager with a light signal, or a smartphone or tablet on a dashboard mount to allow communication with the spotter. If the employer determines that there is a reasonable accommodation that does not pose an undue hardship based on the specific facts, it must provide the accommodation and allow the employee training on the forklift. So I think, just based on the facts of this, some employers would have said, listen, you have hearing loss, you have to be able to communicate with the spotter. I'm sorry, you can't do the forklift training. The EEOC is saying not good enough. You have to explore alternative options, and they give you some here, using a visual tablet, a vibrating pager, using a light signal, something like that. So they're really pushing you to not make automatic decisions in this space with the undue safety threat, in the same way that they're pushing employers not to make automatic decisions with regards to applicants and whether or not they could do the essential functions of the job before they're even granted an interview. I think for employers, it's important to read this guidance through. It is a little bit lengthy, but again, it's full of examples. I think it's very useful. If you are in the space where you're facing this, particularly, I think in the application process, certainly this is something that any of us at Bond are happy to talk with you about, because it is looking like it is going to be a strong priority for the EEOC this year and likely coming into the next several years as well. So with that, Kristen, I'll turn it back to you.
Thanks, Teresa. Appreciate that input. And thanks to all the presenters today for this information. Here's the contact information. If anyone wants to follow up with questions, we always do our best to try to answer the ones that you put here, but sometimes we don't get to all of them. And thanks everyone for listening, and hope you can return with us next week. Take care.